Hi, I'm Todd Lard. Joining me today is Charlie Kearns. We're both part of the Sutherland Salt practice, and we're here to talk about applying transactional taxes to bundles in a digital economy. Now, applying transactional tax to bundles is certainly not a new issue. For example, telecommunications companies for years have offered kind of a bundled service for one price that might include voice, video, internet access. Now, they've been pretty effective in applying the tax regime to those bundles, largely because there's a degree of clarity, I think, in the statute and regulation. But if you kind of move beyond that and move into these new areas of taxation, particularly those that involve digital products or cloud-based software or cloud-based services, it becomes much more, I think, difficult to try to apply the existing framework of laws to those kinds of bundle transactions. If somebody, when you start thinking about how you might apply that, there are some basic considerations I think you have to think about. First of all, you have to make this determination as to whether or not you are in fact offering a bundle. I mean, because you have to look for a kind of a distinct and identifiable components of that kind of make up the bundle. And if you get comfortable with that, then you have to really look at the characterization of each of those components and how they fit together in the bundle, and that largely determines whether or not the entire bundle would be subject to tax or not subject to tax, and then whether or not you might be able to break the bundle apart and tax the components separately. And if that's the case, you have to do, look at things like allocation price, sourcing, but that's kind of just some basic kind of guidelines with respect to how you might analyze it. We've got a little bit of more detailed framework, at least in a few states, that might help you as you think about how to treat your bundle transactions. Charlie, can you give you a little bit of insight on that?
Sure thing. We do have a bit of a framework in some states. So we have two broad categories of states that address bundle transactions. First, we have the streamlined states that must adopt the bundle transaction definition in the agreement, as well as the operating rule in Section 330 of the agreement. In general, those rules apply a de minimis test coupled with a true object test, subject to numerous other exceptions and special rules. Then you have those categories of states that adopt judicially or administratively developed tests, such as the true object test or essence of the transaction test. Now, in all these categories of states, we have special rules, as I mentioned before, especially with respect to telecommunication services.
Now, we have the rules in place. We don't have a lot of guidance, I think, like regulatory guidance on how you might apply it. So what you're really seeing now is a lot of folks with specific fact patterns asking for ruling requests in the different states. We can't talk about all those today, but perhaps we can talk maybe about Utah as an example.
Sure, we certainly have seen a bunch of rulings in the past few months, and Utah is just one. Utah addressed a bundle containing professional reports, data add-ons, and workflow add-ons. Now, the State Tax Commission determined that the true object of the transaction was data processing or access to the vendor's database because the vendor was really selling the professional reports and the data add-ons, and the workflow add-ons was just a de minimis factor in the bundle. Now, the State Tax Commission did note that the workflow add-ons that were separately stated would be taxable as pre-written computer software because, again, they were not part of the bundle.
Now, the Utah ruling actually was conveniently under only the sales and use tax. You have to worry about different taxes, but that's not always the case. I mean, there's a whole nother level of complexity involved when you have a bundle that might have components that are taxed under different regimes. Can we talk a little bit about that?
Definitely, and we typically see this in the communications tax area where you do have a separate regime apart from the general retail sales and use tax, especially in the context of streaming video, which is a common digital product these days. In states like Florida and Kentucky, you have a separate communications tax regime and a general sales and use tax regime that applies to things like tangible personal property. Now, if streaming video were included in a bundle with the general tangible personal property, you may have different bundling rules to deal with in those two regimes, which creates all kinds of compliance issues as well as issues for the state tax administrators when enforcing the tax laws. Well, thanks for joining us today. This is a complex and evolving area of the law. Please check back at our blog, stateandlocaltax.com.